Public Affairs very much thanks Residco, our sole corporate underwriter, for helping to make the production of this show possible.
Welcome to Public Affairs. It's going to be a great show because we have as our guest Judge Daniel Shanes. He is running for the Illinois Supreme Court. Yes, in Illinois, our judges run for election. He is Judge Shanes because he's been 16 years a circuit court judge of Lake County. He is a deputy chief judge?
Deputy chief judge currently, that's right.
Okay. So he's a big shot. And in 16 years, he's overseen 125 trials, major trials like murder, sexual predator. He then, prior to being a judge, he was 12 years a local prosecutor for the assistant state's attorney in Lake County for 12 years, division chief, dealing with civil and criminal matters and many others. 75 trials, jury trials, the 125 that he oversaw as a judge, all jury trials, right?
But jury trials, even more bench trials.
Even more bench trials. As a lawyer, as a prosecutor, tried, as I said, 75 jury trials as an assistant state's attorney in Lake County, and about 200 or more bench trials?
At least.
Judge Shanes, skyrocketing crime. What did judges in the courts have to say about that, especially state courts in the state of Illinois?
Crime is a huge issue, Jeff, and we all know it. In a civilized society, which is what we all want to live in, we are supposed to resolve, and we need to resolve our disputes in the courtroom, not on the street corners, not in the alleyways. Crime is an issue, and the courts are a part of it, but not the only part of it. Of course, it starts with, well, in our judiciary, we have federal system and the state system, and they deal with different crimes. But most crime issues are really state issues. And in fact, if you think of some of the great criminal trials of the last century, Son of Sam, John Wayne Gacy, Charles Manson, they're all state cases. And so most criminal justice issues are in state courts, although our federal brothers and sisters have their hands full too.
But street crime, that's a state court issue. And we say state court, the trial courts are like in Cook County, it would be Circuit Court of Cook County, Lake County, Circuit Court of Lake County.
Correct.
We have 102 counties. Each county has its group of trial courts in that particular county.
Right.
And we got a lot of crime in Chicago, that's in Cook County. But across the state, especially in the inner city areas, we see skyrocketing crime.
We do.
We even see it across the country. What's up, Judge? Why?
Well, so when you see stuff going across the state line, that'll be federal. Of course, most of it doesn't. It's local, like you said. So it's going to be in state court, Circuit Court of Cook County, Circuit Court of Lake County. And just, as a reminder, I'm not a Cook County judge. I'm in Lake County, so I can speak to that.
You got some crime in Lake County?
We have our share of crime in Lake County.
You got some crime in McHenry and DeKalb and Kane and Kendall?
Sadly, there's more crime in all those places than we want.
We're talking murders, we're talking rapes, we're talking robberies, we're talking carjackings.
At any given time on my docket,
lots of violent crime, right?
At any given time on my docket, I probably have a dozen murders pending and more sexual assaults than anyone can count.
Why do you think we're getting so much crime, especially in the last 2 years?
The last 2 years have been a change in criminal justice. When we talk about the crime that we're seeing, it's important to note at least two different things. Crime that we're seeing and cases that are coming to court. Because there could be a whole discussion, and maybe you want to have a whole discussion, on crime that is occurring that perhaps arrests are not being made, prosecutions are not being brought. When it comes to court, the courts don't go looking for cases. The judges don't go finding cases. We have to deal with what is brought to us. So when a crime is committed, police should be investigating those crimes. They do the investigation, they identify the evidence, they find the witnesses, all of that sort of thing.
Who do they arrest?
Well, hopefully...
They just say, hey, that guy looks like somebody I'd like to arrest. They can't do that, can they?
No, they can't do that.
What do they have to have?
They have to have probable cause, part of our Constitution, part of our Fourth Amendment. And in order to support an arrest, there needs to be probable cause that a crime was committed and this person committed the crime. It goes all the way back to our Bill of Rights.
So what happens after that? Say the police arrest, what do they do then?
Well, assume if there's an arrest, then they need to go to the state's attorney. Every county has a state's attorney. And once the police make an arrest, they go to the state's attorney. The state's attorney's office, usually not the state's attorney, but an assistant, would review it, and review it pursuant to the policy that the elected state's attorney has for his or her office. And then they determine whether to bring charges and what charges to bring. It's important in our system of justice with separation of powers, and maybe we'll talk about that more in a bit. But the executive, the state's attorney is part of the executive branch, and the state's attorney has the sole discretion and sole authority to decide what charges to bring and whether to bring charges at all.
102 counties, 102 states' attorneys, 102 individuals making these decisions. You might have been making the decision.
Sure.
Others above you might have been. When did you decide to charge? Did it have to be guilty beyond a reasonable doubt, or what?
I did make those decisions for quite a bit of time. And when I left the state's attorney's office, I was what they call chief of the felony review division, which is the division that reviews charges in felony cases. And there was a staff under me that did it as well.
So what was your standard?
The Constitution requires probable cause.
Okay.
A state's attorney can have a policy from there, not lower, but higher, for whatever that state's attorney thinks is appropriate.
So it should be a matter of, in general, across the state, maybe across the country, an arrest, and the judge and the state's attorney goes to court. If they think the person should not be released, they ask them to hold them without bail, or if they thought the bail should be a certain amount. Now that situation is going to change, but currently the situation is as I described, right? What does the state's attorney want in terms of bail? What has the public defender said? Sure. And then the judge, you're the judge, you decide, right?
I've presided over thousands of bond hearings in my career.
What are the criteria that you say should be used to decide whether this person should be released pending trial or whether the person should be detained? What are your criteria?
And Jeff, you hinted at it. I just mentioned it. This is the law today. This is the law we've had for a couple of centuries. This is the law we'll have until the end of this year, 2022, because January 1st it changes. But under the law today, there are more than 30 different factors that the law provides for a judge to consider in setting what an appropriate bond or bail. Sometimes those words are used interchangeably. The biggest ones all have to do with the nature of the offense. Is it a crime of violence? Is it a possessory offense? Is it a property crime? Things of that nature. What the person's prior criminal history is, prior convictions, contacts with the judicial system, things of that nature, and also flight risk. Do they live here? Are they going to run away? What's their likelihood of returning to court? Things of that nature.
So prior record is important to decide also the danger to the community. That's part of the criteria, right?
Right. The two prongs of bond are really ensuring the defendant will return to court and protect the community while the case is pending.
Okay. Do you think we've been often around the country now? We've heard in San Francisco, the state's attorney, district attorney there was just recalled because maybe that person was a little too lenient on granting people not to be detained, you think?
Well, we have seen nationally district attorneys, state's attorneys, they're called different things, but prosecutors who have run and some successfully been elected because they want to impose their view, whatever their perspective is on criminal justice and shape it or reshape it in some new way. That's a prosecutorial decision, and we've seen a lot of hotly contested state's attorney, district attorney elections around the country. That's not news to anybody.
Okay, so that's a big issue, the so-called social justice warriors. What's your view? We've talked about arrest, we've talked about detention, prosecution, that's the next step, right?
Right.
That should happen if you've already charged, right? You should prosecute.
When the prosecutor charges an offense, they commence the prosecution.
Then there's a trial, bench or jury. Then there's a result, like a conviction or an acquittal. If there's a conviction, there's a sentence, right?
There are a lot of things that happen between A and Z, but yes.
It's a fast show.
It can be. Justice delayed is sometimes justice denied, so it shouldn't take too long. But yes, prosecution, bond hearing, maybe there'll be an indictment if it goes to the grand jury. Of course, there's pretrial litigation and all that. But yeah, ultimately, there'll be a trial, or perhaps the defendant will plead guilty, and then sentencing.
Okay, and then if there's a sentence, sometimes it just says 2 years probation. Means 2 years probation means that person's not going to do any time. they're on probation, right?
Technically,
Usually.
if there's probation, perhaps they'll do some local time in the county jail as part of the probation or not.
But it's not going to be much. It's not going to be 2 years. Right?
No, it's probably not going to be more than a few months. Our justice system, and particularly our criminal justice system, is based upon accountability. If the justice system, and by that I mean the courts, the judges, the prosecutors, the whole system, if our probation officers, if our system does not hold people accountable, then our justice system will fail.
Okay, so you look to the Illinois Constitution and the U.S. Constitution as a judge when you're trying to decide some fundamental things. Is that right?
The Constitution is the touchstone and has to be the touchstone of our system of justice.
And the statutes.
The statutes flow from and follow the Constitution.
And the case law, which is the common law of these stare decisis, which means what?
The case law is the Supreme Court, primarily, deciding how does the law, how do the statutes apply in a given circumstance.
When you said Supreme Court, did you mean to refer to the U.S. Supreme Court or the Illinois Supreme Court?
Oh, both, really.
Both.
Yeah.
They both give you guidance.
They both provide
Their
guidance.
decisions are really important. That's what you're running for, right?
Their decisions are binding on judges across Illinois.
Yeah.
And yes.
You can look at appellate court, but if there's some ambiguity and want some guidance, but it's really what the Supreme say.
The appellate court is binding on the trial courts if an opinion applies, and the appellate court is bound by the Supreme Court as well.
So people should know that in this election on June 28th, we have the primary. In November, there's a general election. In your race, there are 4 candidates in the GOP. It's a contested primary in the 2nd District GOP. We've mentioned the counties.
That's correct.
And then the Democrats also have a contested primary. This election is not about you versus a Democrat. If you win the primary, that will be in November.
We'll get to
the
that.
Democrat versus you.
That's right.
That's the 2nd District.
That's right.
The 3rd District, people should know, there are only, of the 7 seats, there are only 2 seats up this year. These things happen for a variety of reasons at different times. So 2 seats are up, where eventually in November, there will be a Democrat and a Republican running against each other. And right now, what's the margin in the Illinois Supreme Court?
There are 7 judges on the Illinois Supreme Court under our Constitution. 3 are from Cook County. The other 4 are from districts 2, 3, 4, and 5 that are spread across the state. Partisanly, our Supreme Court right now has 4 Democrats and 3 Republicans. It's always had at least 4 Republicans or 4 Democrats, sometimes 5, since our court system came into effect in 1964.
So at least for 60 years, and it was different then, so we won't go back further. For the last 60 years, it's been Democrats in control of the Illinois Supreme Court, and some would say, well, our elections are partisan. No doubt. You're running as a Republican, somebody else running as a Democrat.
That's right.
Some would say, when you put on a robe, you don't put on a blue robe or a red robe, do you?
You've heard me say it.
Yeah.
That's right. So in Illinois, our Constitution provides that judges get elected and get elected through the partisan system. So I was elected as a circuit judge as a Republican. I'm running for Supreme Court as a Republican. There are others running on both sides. You're exactly right. But, and we did talk about it before, when I go to work, when I take the bench, when I sit down and serve as a judge, you're exactly right. The robe's not red, it's not blue, it's black, because a judge's oath is to the Constitution and to the rule of law. No, I believe words matter, and words have to be understood in a consistent way, because our freedoms and our liberties reside in our Constitution. And the way to protect them, the way that everyone in our community, that each citizen and person who comes before the court can be best guaranteed to be treated fairly, is if every judge, and each individual judge, understands and applies the Constitution and the law in a similar way. So if judges are free to reinterpret, reapply the Constitution in a different way, or if I'm free to do it Monday, Wednesday, Friday one way, Tuesday, Thursday in another way, or maybe I didn't have a good lunch and in the afternoon I'm doing it differently, nobody's free from me, and that's arbitrary power.
So would you describe yourself as an originalist, as a textualist?
We've seen over the decades a lot of these names.
What does that mean if you would describe yourself that way?
What is
words.
being an originalist or something like that
Yeah.
mean? Sure, no, it means what I said. It means that words have meaning and that those words have to be understood in a consistent
And
manner.
the words in the Illinois Constitution have meaning as they were written. What did they say? And the words in the U.S. Supreme Court, because that will affect you as well,
Right.
and the words of the statute have meaning.
Our federal Constitution was originally written over 200 years ago, and it's been amended 27 times.
And
The Illinois Constitution, of course, came in 1970. And the founders of the Illinois Constitution and the founders of the federal Constitution gave us a way to change what the Constitution says. They didn't say, pick judges who will reinterpret it. They said, amend it.
Yeah.
And that's our process.
invocation by Governor Pritzker of emergency powers. We have a statute that gives him the power to invoke emergency powers in 30 days. That lasts for 30 days. If he wants to extend it, he has to seek to invoke it again and again and again. And he did that almost, I think now 28 times in the last 2 years. Usurpation by the executive of the legislative powers, or a reasonable practice by Governor Pritzker? What do you think?
It's 28 times because it's been 28 months since COVID started, right? And it's every 30 days. And I think that's right. That's what's happening.
Even in the when we think COVID was over, recently in the last month, he's invoked it again, right?
Last week, perhaps.
Yeah, it's happened kind of quietly. Some people are wondering, why is he doing this? Where's the emergency?
After 28 times, I think people maybe stop noticing. I don't know. Our freedoms really reside in the genius of the Constitution. And when we talk about our state constitution and our state freedom, and from a state court perspective, it's the separation of powers. Our state constitution mimics the federal constitution in 3 branches of government: the executive, the legislature, and the judiciary. Each of those branches of government has its own responsibility and ability to exercise authority. Each has to do that. The governor has to have some sort of emergency powers. Think Hurricane Katrina.
Granted.
Right?
But does he have the power to basically put the legislature aside? Perhaps the Democratic legislature was very willing for more than 28 months. Does he have the power? Should he keep doing it?
What's one of the powers and responsibilities of the judicial branch? To make sure that the other 2 branches are exercising their powers in an appropriate way. That's both not more than the power that they have and not less than the responsibility that they have.
So they could, if there was a case in controversy before them, they could decide under their power of judicial review. You, if you were there and your 6 colleagues on the Supreme Court, could strike that down and say that's an unconstitutional invocation of your powers, Governor, if presented to you.
These cases are percolating through the courts. They're all throughout the lower courts right now, and we've seen at least one appellate court touch on it, and the Supreme Court touch but not rule on the merits of it, finally, because of legislative action. And yes, all these cases are funneling through the courts, and they all end up at the Illinois Supreme Court. The legislature this past summer, 2021, when they redid all the legislative maps, about a half an hour later, they redid the Supreme Court map for the first time since 1964.
And something that was red became purple, the district you're running in, right?
In the old map, the 2nd district the 2nd district was historically more Republican. The 3rd district has elected a Democrat years ago, but I'd say the last 10, 15, 20 years has turned more Republican.
Well, that Democrat lost in a retention just 2 years ago, so that's a sign that what was a blue district had become perhaps a red district, and they switched it back, the Dems did, in their redistricting to make it purple. So now when you view, we got 2 purple districts, 2nd and 3rd, and this vote is really important, whether you end up with 2 Republicans winning, 2 Democrats. But if 2 Republicans win, for the first time in 60 years, you would have a 4-3 Republican majority, right?
That's exactly right. For the first time in 60 years, 2 Republicans win, you'll have a 4-3 Republican majority. If it goes the other way, you'll have a 5-2 Democratic majority. But I'll tell you, I think it's more than the politics, because it's who we're putting on the Supreme Court. It's the candidates, it's the people.
Character matters.
That's right.
Experience matters. Judicial temperament matters. Approach to law matters. You're running on that, all right? You've been running for a year, in a sense, right?
When the map changed, I announced I was running for the Illinois Supreme Court.
It's been about a year?
It's been, a year and a week, perhaps.
Okay, so this stuff matters. Those 4 things you've been telling people about. And people, you'll judge. I hope I don't have a lot of bias here. Everybody's got some. But I mean, look, it's not my view that matters. It's your view. What do you think of this guy's experience, his character, his temperament, his approach to the law? Did I leave anything out? Does that cover it?
Yeah, that covers a lot of ground.
Okay. So, yeah, like people, they should know that redistricting, well, it came up 3 or 4 years ago. It went to the court. You know, they took an initiative. We allow in Illinois an initiative to say we want to have fair maps, right? We want to change our redistricting process, right? And there was an initiative to do that, and it had the signatures, and it presumably was going to be put on the ballot. Somebody challenged it. Did I get that right? And what did the Supreme say?
No, that's right. There was an initiative. Illinois Constitution allows initiatives. We see them from time to time. There was an initiative. There were, I think, hundreds of thousands of signatures on it, and it went to the courts because the courts are ultimately what resolves this.
And what was the margin of the courts at that time? 4-3 Dems?
A majority of the Illinois Supreme Court struck down the ballot initiative.
What was the vote? 4-3, 5-2? Do you know?
It was 4-3.
Dems on one side, Republicans on the other.
The majority were the 4.
Mike Madigan, clearly the most powerful person until a year ago, when he was Speaker for, 35 years, except when he took a coffee break in 94.
Lee Daniels' term?
Yes, a coffee break. Most powerful person, more powerful than certainly the governors. He abhorred the idea of this redistricting, but the one thing he wanted was strike that baby down, and he got that. I ask you, sir, was the Illinois Supreme Court acting politically on that day when they cast that vote?
The judges on the Illinois Supreme Court issued several opinions on that, and I urge voters to read it. You could read the majority opinion. You can read Justice Thomas's opinion, Justice Carmeyer's opinion. I thought they were some of the strongest and clearest opinions that I've seen out of the Supreme Court in a long time.
So it matters.
It matters who your judges
Who's on
are.
the Supreme Court? Folks, it matters in November when you vote, and especially in the second. You have to be in the second district or the third district to have a vote here, and you have to, in this vote, and on June 28th, to vote in the primary on who your representative will be for the Republican Party. You've got to ask for a Republican ballot. Some people think I have to be registered as a Republican. No. You just ask. If you want to be a Democrat that day, just ask for a Democratic ballot. But if you ask for a Republican ballot and you live in the second or third, you got a voice in this election on what the Supreme Court choices will be, at least in November. And in the primary in the third, there's only one, it's not a contested on the Democratic and Republican side.
Right.
So your vote will be in November. But so we got it. It matters on empowerment, on how much power the executive had, the governor had. Did he do right on the emergency powers? It matters on crime. It matters on pensions. As you know, the Illinois Supreme Court ruled on the so-called pension clause. The Illinois Constitution says what about pensions?
The Illinois Constitution has a clause, unlike our federal Constitution, that talks about reducing pensions, essentially.
You can't do it according to the Constitution if you construe it as the court did at that time when it was before them. And so, fine, if you want to amend the Constitution, you can do that. But other than that, you can't cut pension benefits. They didn't really care, did they? The $530 billion pension hole, state and local, says wire points. I don't know. It might have been $400 billion at that time, $350, still pretty large. Supreme Court didn't have to consider that. They just said, here's our view, that's it. But another Supreme Court with different justices may reach a different decision on the pension clause. May, right? You
mentioned stare decisis before. That's what that's about.
You might reach a different decision than they did, right?
Every judge needs to approach every case with an open mind. And as you talked about before, judges cannot prejudge cases. We don't want that. As we look to this, yes, the Illinois Supreme, here's a factoid for our viewers. The Illinois Supreme Court decided the big pension case, as it's referred to, quite some time ago. Stare decisis, a legal principle you referred to, essentially says, don't change settled law unless it really needs to be changed. And what constitutes that is a whole other conversation. After this election, I believe none of the judges who were part of the decision on the original pension case will actually be on the Supreme Court anymore. All 7 would be new.
Yes, and if you were one of them, you would have a fresh view along with the other 6, right?
I would view the law as it stands. I would interpret the Constitution as I understand it.
Yeah, so you can't decide that now, But you could tell us maybe, judges should understand the consequences of their decisions, and they should presumably take that into account. And if they rule as the Illinois Supreme Court did previously, that $500 billion pension hole is not going to be cured by lowering pension benefits. All we got left is to raise taxes. In a sense, then, if you voted that way, you'd be raising taxes substantially, maybe in a way that nobody could imagine is feasible.
You know, Jeff, we live...
Is all of that in your mindset as you run and think about this as to what your decision would be about that pension policy?
Jeff, you and I live in the real world. We live with our neighbors. We work with our friends and colleagues, and we have to be aware of and cognizant of what's going on. But part of the genius of the Constitution is that judges should not exercise their authority to simply fix societal problems, and pension is one of them, because clever lawyers will always come into court and have a solution that they couldn't get through the legislature, couldn't get through the political branches, and want judges to fix.
But if somebody had an initiative on the ballot and the signatures were there and everything looked kosher, so to speak, okay? Everything looked right, all had complied with statutes and the Constitution, you might be less apt to strike that down, because then if you amend the Constitution, then the legislature, who is the appropriate entity to make those policy choices, they would have that. They can't do that now unless you decide to let that initiative go forward and have redistricting. And actually, that was a redistricting decision. But in the same way, you might decide if there was an amendment on the ballot to amend the Constitution, if the voters approved that, if it got on the ballot, well, then that Constitution, that protection clause that protected those public sector pensions could be changed. So there are multiple ways in which you as a Supreme Court justice can give more power or less to the other branches.
How the Supreme Court rules certainly can affect the power that not just the other branches have, but people have.
Would you think it would be helpful to have term limits by the state legislators, state reps, state senators, also statewide offices, also governor?
Yeah, interestingly, we have terms for judges also.
Right.
And there's a strong argument for that. And it's particularly has tension with judicial branch because it's the balance of judicial independence, which is why Hamilton and Jay and the others who were the founders when they wrote in the Federalist Papers, Hamilton wrote in the Federalist Papers that federal judges would be insulated by lifetime tenure. Our state has chosen that judges do not have lifetime tenure. It's on the Supreme Court, it's a 10-year term with a yes-no retention at the end. There's probably less need for term limits in the judiciary than there are in the other branches, but people will also tell you every state rep has a term limit of 2 years and then he has to run again. Every senator, 4 years, every governor, 4 years.
What about on the federal level? Should there be term limits there?
Well, we have state and federal. What we have seen that our founding fathers did not predict is the entrenchment of a political class, really. But our founders also did not predict the entrenchment of a bureaucracy underlying that government. I sometimes wonder whether one of my heroes, John Adams, if he dropped out of the sky and landed in the Beltway, would recognize the federal government, the very government he helped form.
On this election, June 28th, how they want to vote in the Republican primary, because our guest, Judge Daniel Shaines, is on that ballot in the 2nd District, in 5 counties. What are those 5 counties?
Lake County, McHenry, Kane, Kendall, and DeKalb.
If you live in there and you take a Republican ballot, you get to judge about Judge Daniel Shaines. Make that judgment, and you come back next week and every week to Public Affairs.